Hello, I'm Jared Karchner with the Northern Virginia Estate Planning Law Practice, and today's discussion is going to be about online legal forms. Are online legal forms legally binding? Now, you've seen this question before. Perhaps you've even asked it yourself. Maybe you keyed that very question into your search bar just now and ended up with this discussion as a search result. Well, without any further ado, here's the answer to that question. It's the wrong question. Really. Here's the question you should be asking. Will the online form I'm looking for solve the problem I currently have without creating other problems for me? Focusing on whether a document is legally binding without understanding the full ramifications of that form can present some fairly serious consequences. The largest risk isn't that a form isn't legally binding, but that it is. Let's use one of the most common examples, an online will, to explore this. Despite the guided questionnaires, people do make mistakes on these forms. Children get omitted, assets that aren't part of the estate get included, gifts to classes of heirs that are invalid get included, etc. Without the benefit of professional guidance, these errors generally aren't discovered until after the person who made the will has passed away. At that point, it's too late to change the will, and some of the person's intended beneficiaries get disinherited. Why? Because the will was legally binding. Here's another example of how focusing on the wrong question, is it legally binding, can get you into a lot of trouble. Let's say you own some real estate in your own name, subject to a mortgage, and you want to set up some sort of an asset protection structure to protect that property from future creditors. Now, you do a little bit of research online, and you decide that you'll set up a trust to transfer the property into, and then for good measure, transfer the property from the trust into a limited liability company. These are both structures that you can set up online and are pretty straightforward transactions. Now, here's the problem. Your mortgage company most likely has a due on sale clause written into the terms of the note, which means that if you decide to transfer the property to someone else, the balance on the note that you thought you still had years to pay on is fully due immediately. Technically, although a transfer from yourself as the owner of the property to yourself as a trustee of the trust is a change in ownership that would trigger a due on sale clause, federal law allows you to transfer property from your name to your trust as long as there's no material change in the beneficial ownership. Once the trust transfers the property to the LLC, though, the mortgage company's collateral is at risk because the LLC is a distinct legal entity. So as a result, while the first transfer wouldn't trigger the note being accelerated, the second one would. Now, could you use an online provider to set up a trust? Yes. Could you use an online provider to set up an LLC? Yes. Could you transfer your property from yourself to your trust? Yes. Could you then transfer the property from your trust to your LLC? Again, yes. Would each of the foregoing transactions be legally binding? Yes. Is owing the entire balance on your outstanding loan the result you want? No, not at all, but it's legally binding, just like you wanted it to be. Now, these are just a couple of examples as to why is it legally binding is the wrong question. If you have a legal problem, seek legal advice that will solve that problem without creating newer ones in its place. If you have any questions, please reach out to me at jared@novaestateplanning.com or explore the resources at my website at novaestateplanning.com. Thanks for watching, and I'll see you next time.